The promise of any modern democracy is that the justice system is open to everyone, regardless of what's in their bank account. But entry to Te Koti Mana Nui o Aotearoa, New Zealand's Supreme Court, comes with a financial requirement. To have your case heard by the highest court in the land, you first have to pay for the privilege. Filing fees aren't new. The court uses them to maintain operations, manage the registry, and enforce a baseline level of order. The system also relies on Section 166 orders. Think of this as a strict filter. If a litigant has a history of filing repetitive, meritless lawsuits, a Section 166 order blocks them from launching new proceedings without explicit permission. It stops the waste of millions in taxpayer dollars. To balance these strict barriers, the court has a safety valve. If you are entirely out of funds, but your case represents a genuine matter of public interest, you can apply for a fee waiver to bypass those costs. The tension arises when the rules designed to block nuisance lawsuits become so rigid that they financially lock out the people those waivers were built to protect. A 2026 Supreme Court ruling, Seamer v. Attorney General, stress-tested this exact dynamic. On one side, you have the Crown, on the other, a single self-represented citizen. The applicant's financial reality was straightforward. He relied entirely on New Zealand superannuation, with no excess capital to fund a drawn-out legal fight. So he applied for a fee waiver, arguing specifically that his legal challenge was a matter of genuine public interest. The Supreme Court took a specific path here. They formally assumed, without actually deciding, that his case did concern a genuine matter of public interest. Even with that assumption, the court denied the fee waiver. Their reasoning was that the applicant failed to prove his case would completely halt without the financial help. To back this up, the judges pointed to his own conduct. Because he was actively filing other applications and procedural documents in parallel, they concluded he was physically capable of keeping the fight going. By separating the public interest value of a case from the applicant's need for financial aid, the court places the burden of constitutional challenges entirely on an individual's economic endurance. The court's logic creates a cycle where the very act of trying to participate in the legal process is used as evidence that you don't need financial assistance. Let's view this trap. Option A, stop filing to prove you lack funds, and your case is struck out for inactivity. Option B, scrape together pennies to file a plea, and the court uses that document to deny the waiver. In Seamer's case, the court categorized his repeated filings as a recall application, an impermissible attempt to relitigate. That classification permanently ends the procedural road. By cementing this circular logic, the judicial system weaponizes a vulnerable litigant's own desperate attempts to participate, using their fight against them. Zooming out from the Seamer case, we have to look at what this strict bureaucratic precedent means for future civil rights disputes across Aotearoa. Rigid financial thresholds do not affect all citizens equally. They place a disproportionate weight on communities already facing systemic socio-economic disadvantages. For Maori, this creates a specific barrier to ori-tatanga, or equality of citizenship. When the gate to the Supreme Court requires a level of wealth many communities statistically lack, the ability to challenge the Crown through the law becomes a luxury rather than a right. It raises a pressing ethical question. If a case genuinely serves the public interest, shouldn't the state facilitate a resolution rather than testing the economic breaking point of the person bringing it forward? This establishes a quiet, chilling effect. Valid, systemic challenges simply die off before reaching the courtroom steps, abandoned by citizens who realize they cannot outspend the state. The Supreme Court successfully protected its registry from a repetitive litigant. Yet in doing so, they reinforced an apex court that operates as a financial arena, where only the wealthy, or the Crown itself, can comfortably afford the price of admission.